Welcome, everybody. We appreciate you joining us today. I'm JoAnne Hamberg with Real Estate Exchange. And today I have Nancy Catalini Chu, attorney Nancy Catalini Chu, who specializes in elder care and estate planning. So, Nancy, tell us a little bit about yourself and your company.
Absolutely. So I am a sole practitioner in Harvard. And as you just said, JoAnne, I practice exclusively estate planning and elder law for the last at least 25 years, slightly over, I'm sorry to say. And that has been my focus since I left the federal government. So I used to work as a federal government attorney, but for the last, like I say, 25 plus years, this has been my sole focus.
Well, you've helped me a lot over the years. So,
There you
so
go.
a lot of times, when I meet with people, they're always like, "Wow, why do I need estate planning? Why is it so important?" So, what do you say about that?
So what I say to people is what all estate planning really does, if you think about it, is preserve your wishes. So if you don't do any type of planning, then the government decides, either the state or the federal government decides where your assets pass at your death. They have a hearing to decide who's going to make your medical and financial decisions. And that might not be what you would have chosen for yourself. So it's your ability to choose in advance where I want my assets to pass and roadmap who the alternates might be if those people don't survive me, as well as choose your fiduciaries to either handle your affairs at death or take care of your finances or medical decisions during your lifetime. And so that's the real impetus for doing it, is so that you can elect all of those roles and beneficiaries.
Well, I'm sure like everybody's different, so there must be like different like components, I guess. So, like, what are the key components that someone should have as a basic estate plan before they add on all the extra stuff? And
Yeah.
like, is there like an outline or?
Yeah. And so what I consider the foundation, you're building a house, you have a foundation. And so what are the foundational documents everyone should have, regardless of age or circumstance? And those are, on the financial side, a power of attorney who can pay my bills, file my taxes, collect my mail, deal with Social Security, whatever needs to be done for you if you're alive, but need
Mhm.
help or can't truly function to do those things for yourself. And so that's a key document. And people say, what if I don't have one and something happens to me? Then we have to go to court. And that's where I mentioned earlier, then the court is deciding who's going to do that for you. So it's your opportunity to pick that out. And on the medical side of things, we want to make sure you're deciding who's going to make my medical decisions for me if I can't. That's a healthcare proxy. And most people have heard of that document. And frequently you can get that from your actual physician. So that's that one. And then you want to have a HIPAA release as well, so that the people of your choosing can talk with the doctors and nurses to find out what's going on and what pill is that, because we have those federal privacy laws that dictate who can they get that information to, and it's not necessarily the exhaustive list. And actually, your spouse, children, parents are not automatically included. So you want to make sure that you have that in place as well.
So definitely power of attorney should be number one. Um, and then you
The
said the
healthcare
HIPAA,
document.
the healthcare documents. Um, that's important. I know for me, when we sat down, it's like, all right, who's going to pull the plug on me? So you have to kind of think
Yeah,
about, it's a lot
yeah.
to think about when you're going through it. Like, all right, now I'm dead, and who's going to
It,
do what,
it
you know?
is. It is. And you hopefully are making those decisions before those are pressing and stressful and difficult to make, so that you can really put some thought into who you want to do those roles and have the opportunity to talk with them about it. I'm fond of
Yeah.
saying no one's ever said to me, I wish I had less information about what someone wanted. We all hope to have ample conversation. What do you want? Why do you want it? How would you like to your final days to play out? How can I assist with that? So those conversations really help reinforce what you've said kind of black and white in your documents.
So we didn't talk about a will. What about a will? Now,
Yeah, so those are as we said, the foundational documents everyone should have, regardless of age and circumstance, that see you through
mhm,
life. But to your point, JoAnne, what happens when I pass away? And the frequent question I get is, what's the difference between a will and a trust? How do I decide which one I want? How are they similar? How are they different? And what a lot of people don't realize is that you can transfer assets upon your passing without a will or a trust. So your retirement assets or your life insurance lend themselves to a beneficiary designation, and that trumps everything else. So whether you have a will or a trust, it's irrelevant to those things. And so that's why we can actually structure a lot of assets. Joint ownership is another good example where they pass automatically to people and we don't actually even need to worry about a will or a trust. But
mhm.
then there are assets in a typical portfolio that don't lend themselves to a beneficiary or necessarily a joint ownership. Real estate, automobiles, bank accounts are the most common examples of that. And so, how do you pass those assets at death? If you leave them in your name and they don't have a beneficiary or a joint ownership, then we use a will to pass them. You don't change anything while you're alive, but the will does all of that work at your death. I'm sorry, I have a barking dog in the other room who won't seem to
So,
stop. So that's what you're hearing. I'm going to close the door so you can't hear it.
okay. And if
It's
anyone has any questions, you're welcome to put them in the chat box and we will try
Don't
to
weigh in
address
on
them
them.
as we go through.
And so the will allows them to pass, but that requires a probate process. And so people always say, what is probate? And why does it get such a bad reputation? And probate is transitioning those assets that don't have a joint owner or a beneficiary to your intended beneficiaries. We have to read the will to figure out where you want them to go. And even though the will is a written document, we needed to go through the mandated state process known as probate, where you offer it to the court. They vet it out, make sure it's legitimately executed. Nobody objects to it. So none of the heirs are saying, no, that's not the will, or they weren't competent when they signed it. But once they go through that process and authenticate the will, then the will can be carried out under the court's auspices, but that probate process takes over a year to complete by state mandate. And so that process is lengthy and sometimes expensive, which is why people want to figure out an alternative to it. And the alternative to that is to create a trust. A trust at its core is really a fancy beneficiary designation you write yourself. And so within the terms of it, it says where I want things to pass, and you transfer assets to it while you're alive. And that's what bypasses the court because it functions like a beneficiary designation. So that's why how you create an alternative. And then people ask me, okay, well, then how do I determine which one I prefer? And I think ultimately it boils down to a couple of things. One, your family tree. So the use of a will and the court process requires us to notify everyone who's your next of kin, whether you want them to
Or not.
inherit or not. And right, so some people don't like that, or they don't have children, and so they want to leave it to their friends or charities, and they don't want to necessarily find their third cousin they haven't spoken to or don't even know who it is. But the court process requires us to find those people. But with a trust, it's only a contract between you and your beneficiaries, so we can avoid all of that probate notification. So for some people, it's that family tree dynamic, or they're estranged from a family member. But for most people, it's really just an administrative choice that they want it to be as simple as possible for the people they leave behind. So they want to cut out all of that court formality, delay, time, and expense. And the way that you do that with a trust is that a trust allows you, because you've done so much work while you're alive to get your assets into it, there's very little a trustee needs to do after the fact, other than basically pay your bills and file your taxes. I don't know what is wrong with that dog, so let's go find out what that is. I'm sorry. Come up with
so just like on your saying, Nancy, the big thing is a lot of people, you should definitely have a beneficiary on your savings accounts, your life insurance, your stocks, your bonds, your checking account, just so that there is someone who's a beneficiary in case you don't have your will or a trust set up. So that's something everybody should try to do, and you should definitely have a power of attorney and have a copy at home, and then whoever your power of attorney is should have a copy in case you need it. People always think that a power of attorney can do things without you and it's like sell your house and stuff, but it takes a lot more than that. You can't just turn over a house without the proper paperwork and stuff. So you definitely need a power of attorney for settling out like checking accounts and paying your bills and stuff like that. But the other thing is a power of attorney is no longer valid after someone passes away. So that's where the trust or the will really come in handy. So something to think about. What happens if you die without a will, it's called intestate, then you have to go through probate, and someone has to go through that whole process, which they would hire you as an attorney to help with that. The trust, now there's a living trust, and then there's another trust, irrevocable trust.
Yeah.
Can you explain a little bit about those?
I can. So in the context that we've been talking about as an alternative to a will, you're largely talking about what they call a revocable living trust. And so there's irrevocable and there's testamentary as the alternatives to that. So let's pull that apart. So revocable versus irrevocable. Most people, again, would prefer a revocable trust so they can amend it anytime they want, just like a will, your traditional concept of a will. And so that's what revocable means. I can amend it, I can change it. It's a living document while I'm alive. And why do people use an irrevocable trust? It basically boils down to two reasons. One is largely tax. So if I'm trying to keep an asset from being taxed at my death under estate tax rules, then I sort of need to create a separation from it while I'm alive. And how do I separate myself from an asset? I put it into an irrevocable trust. It has its own tax identification number. It files its own taxes if necessary. And so it creates a separation so that at my death, those assets are no longer taxed as mine. So for people with significant estate tax issues, sometimes we're looking at an estate tax consequence, and thus an irrevocable trust is something warranted to include in the conversation. The primary other reason people do an irrevocable trust, similar in the sense that you're trying to separate an asset from your portfolio, is to protect it against future long-term care costs. So if I ever need a nursing home or the state to pay for my care, I don't want that asset to count because I'm trying to save it for kids or whomever. And so in order to effectuate that, I need to have removed it from my name during my lifetime. And one of the options is to create an irrevocable trust, again, separate tax ID number, separate entity, and move the asset into it long enough in advance of my needing care so that it will be separate from me. So if you're not looking at a tax consequence and you're not looking for that long-term care protection for a specific asset, then you're traditionally looking at a revocable trust. And then the other piece to it in looking at the matrix of trusts, is it a living trust or what they call an inter vivos trust, which is Latin for living, or is it a testamentary trust from your last will and testament? And so essentially you can have a revocable or irrevocable trust created by your will, doesn't exist until your death. Most frequently, those are, I'm going to leave everything to my kids, but if one of them's under a certain age, then a trust will jump up and take care of them until that age. But it really doesn't exist until all of that is known and actually happens. through your last will and testament. If you're putting assets into something, some kind of trust while you're alive, and you want that trust to be in place at your death, then that's a living trust created while you're alive. So that's the difference. Created alive, created at death, revocable, irrevocable. Those are kind of the crosshatch of choices when you're looking at trusts.
So one of the things you mentioned, I was going to bring up is what about children? So say your children are under 18 and you're not ready for them to inherit any of this stuff. Would you just do that through a living trust, or what would be the way to handle that?
And that's a good question, because there are probably as many people as choose one over the other. And what's the difference? So some people just say, I'm going to use a traditional will. In that will, I will say it's going to my kids. If they're under that age at the time of my death, the age I pick, then it's going to continue in trust for them. You can certainly do it that way. But the concern with that is that, let's say you pass away and the kids are 12 and 14. And I don't want the trust to end and for them to get their money till they're 25, 28, 30, whatever age you pick, because you and I agree 18 is probably not the wisest age to have money. And so we pick a higher age than that. If they die and there's still 10, 12, 15 years that someone's going to probably be their trustee, and it's been done in a will, you're looking at annual fees and accountings to the court. It's not one and done at your death. It's an ongoing process, because the court continues to oversee it until that trust that was nested in the will can finally come to conclusion. So that's why a lot of times people elect the trust as well, is that if the trust is buried in a trust versus being buried in a will, then the trust never was part of the court process to begin with. And it can have exactly the same terms, but there's not the obligation to have an annual accounting to the court or the court fees and oversight. But sometimes people still like that option of the court fees and oversight, because it provides an avenue for objection. And what does that mean? So let's say trust is created and the child gets to 19 years old and there's a problem. The trustee is not cooperative. They don't ever want to give them any money. They're concerned the trustee is not using and investing the money the way they should. There's some concern. If it's been done through the court process, then you just go into court and say, you're overseeing this trust. I think there's a problem. I'm the beneficiary, and the court automatically takes control over it. If you've decided to privatize it with a trust because you liked all of that privacy, that also means that there's no opportunity available for an objection short of us bringing them to court. And so that requires the beneficiary to file a lawsuit, which may not be the most appealing or cheapest option for them. So that's the difference between nesting a trust for them within a trust or nesting it within a will.
That's interesting. How difficult and how expensive is it to go through probate? Like,
so that's that's kind of a hard one to nail down, because I speak to my own experience. I see plenty of attorneys who charge basically a percentage of the estate, which is actually not what you're supposed to be able to do, but I still see it happen. Mm-hmm. It's supposed to be based on the actual time that you do work on it. And so there's a couple of components to it. One is court filing fees. So there's a fee you pay the court to accept the filing. There's a fee every time you want them to do something. And usually over the life of a probate, you might see anywhere from 1,000 to 2,000 in court fees. And so, that's not insignificant in and of itself. And then you have to add what most people require, either CPA and or financial planner and or attorney to help them through the process. So there's all of those pieces to it as well, and all of the fees that those people charge to assist with that. So I would comfortably say that soup to nuts, if you need all of those things, you might be looking at somewhere between 10 and $20,000 to do a probate if you are the more complicated end of that. So it's not an insignificant amount of money, fees and court expenses included. Then and a lot of people say to me, well, I'll be dead, so I don't care what it costs. There's not the practical answer to
It's
that.
true.
But cost benefit analysis, if you really were to compare it to a trust might require a couple thousand to create, but it's also avoiding, and whereas a will is only maybe a few hundred, but there's also eliminating all of that or most of that. You'll still need some tax, you might still need some minor legal or financial advice, but you're significantly, maybe 20% of that is what you're looking at for fees at the end of the day, as opposed to all of that for probate. So yes, if you had the ability to look at the totality of it, a trust is less expensive. But if you're only looking at lifetime expense, you're going to pay more for a trust than a will.
Okay. What about, like you pick somebody to oversee it, an executor or a trustee. Do you have any words of wisdom on like the best way to pick somebody? Are you better off to hire an attorney to be handle your estate, or is it better to have a family member, husband, wife, brother?
Yep. And people ask that question, and interestingly, I've seen attorneys just say they should never name a family member. That has not been my experience. I'm a big fan of blood is thicker than water, and people who have a vested interest in it are going to be not only singularly focused on what you have going on, whereas a professional has probably many clients they're trying to service at once, but they have a vested interest in getting to a conclusion that's financially sensible. Most of the time they want to preserve as much for the beneficiaries, so they're not extending it or billing unnecessarily, so to speak. So I don't necessarily push my clients to go to a professional. I think you have to assess who you have available. If you have reasonable, you don't have to be an expert in it. You don't have to have experience in it. But if you have people who are reasonable, can follow instructions, and won't unnecessarily draw it out. They're not the world's biggest procrastinator. I get a letter in the mail from the attorney. They say, sign these forms, send them in, go to the bank, do X, Y, and Z. And I can do that in a reasonable amount of time. Then those are probably your better choice. But there are many times people don't have reasonable choices, or they don't have people who live locally, or they just don't have whatever skill set is necessary to do that. And they look for a professional. And yet you can use a CPA. Some financial planners, but not all, can do that. Some attorneys will do that. There are certainly trust companies as well. And sometimes people do a hybrid. So they have a personal person and they have a professional to work together, because they like I call it the good cop, bad cop scenario, where we have family member who's the good cop, and then we have the professional who can kind of toe the line, remind us, we got to take care of that tax filing. We got to make sure that we're crossing all our T's and dotting all of our I's. And so sometimes people like that combination instead of choosing a professional or a personal.
What happens? I pass away, and how does my estate affect my heirs, like taxes, and how do they inherit it? How does that work?
So one of the only good news things I get to give people is that any tax is borne by the estate, not by the beneficiaries. So that means if I have income taxes that I owe at my death, if there are estate taxes owed at my death, all of that is accounted for by the fiduciary, whether it's a trustee or under a trust, or a personal representative under a will, and everything is taken care of before it gets distributed. So once I get my check as a beneficiary, I don't owe any tax on it. And sometimes I get the question, well, doesn't it say on the tax form gifts? Yes, but they're talking about things like you won the lottery or you gambled something at Foxwoods. Inheritances are tax-free once the taxes of the decedent have been paid. So there's no tax to them. And the other nice thing that we still have until Congress changes it, hopefully they don't, is what they call a step up in basis. So I own, let's say, a house, and I bought it for 100,000. And while I owned it, it grew to 300,000 in value. So that 200,000 in growth is called gain. And if and when I sell it, I'm going to pay a portion of that, 20% currently in Massachusetts, between federal and mass. When I sell it, that's a gain I'm going to owe at tax time. But if I die owning it and it's grown 200,000 and I never sold it, then that gain is erased. They call that a step up in basis. Well, nobody cares that I paid 100,000 for it. If I die, it's worth 300,000. My beneficiaries start at 300,000. So they turn around 2 months later and they sell it for 300,000 and $5. They're only going to pay tax on the $5 growth, not on any of the growth I enjoyed while I was alive. So that's
Yeah.
a big benefit.
I think I've had a few people, we've gone through this, and someone has passed away and it's been a few years, and they're like, well, I'm going to sell it now. And so I explained to them, go back either to the assessor's office and see what it
Yes.
was assessed at, or find an appraiser that would give you an appraised value of what that property was worth at the time of their death, because that can be a huge adjustment in capital gains.
Yes, absolutely.
Like, so
Absolutely.
when my brother passed away, he had 5 properties. We had them all appraised and we put them away in the files. So we'll have them for another day.
Yeah.
But I mean, I would rather pay capital gains on the 300 over than to pay it on the first 300 if we didn't have to. And
Absolutely. Absolutely. And a lot of people, like you say, just kind of inherit and sit on the asset and don't realize, yeah, you got to step up in basis. Or there was a married couple and there was a partial step up at the first death, and they sell before the second spouse dies, and they're trying to figure all that out. So that's a common question that we get. And what's interesting with investments, it used to be that you kind of had to, you were on your own for that, tracking your basis. And now the government is requiring companies to be able to provide you with your basis and assets upon request. So that's helping a lot for your consumer, who doesn't necessarily know. And then they find out, come to your point, JoAnne, they find out later, oh, I got to step up in basis. How do I retroactively go back and find out what that value was? The company now is required to do that and not just brush you off.
oh, that's good. Because yeah, like I said, if you didn't know, you wouldn't know, and you
Right.
just go and sell it, and then you just give the government more money than we need to.
Yeah. Yeah. Nobody wants that.
No, no. When you talked about the healthcare proxy, what's included in that? Is that, I mean, like we talked about pulling the plug if I'm really bad. I mean,
Yes.
what kind of things are in
And
the healthcare proxy?
under Massachusetts law, I call it soup to nuts. Everything from the easy and minor, I need an x-ray, I need my appendix out, to the really difficult end of life, nuanced decisions. I need to determine whether nourishment and hydration are going to be withdrawn, whether this person needs intubation, all of those, mental health treatment, all the things that make the hair on your neck stand up. Somebody you name as the healthcare agent will have to decide those things. And hopefully they've had a conversation with you. What's interesting is that in Massachusetts, you can put together a living will and or advance directive, or you can even talk with a doctor, do what is now called a MOLST, but used to be called a DNR, and say what you want. But your agent can always undo it, reverse it, and act counter to it. So that's, Massachusetts has decided you really don't know until it happens. And so they're very particular in not over limiting the agent. And that's frustrating for some people because they say, no, I want it to be what I want it to be. But again, that's their rationale. That's why choice of agent is so important, that you feel it's somebody who really understands what you want and your kind of philosophy. And you think we'll have the wherewithal to, even if a doctor wants to give them a hard time, say, no, this is what we're going to do.
Yeah. So let's talk about something happy. Now,
Okay.
you're older, and unfortunately we only live so long. What about gifting to my grandkids or my children before I pass away, so that I can give it to them and they can enjoy it with
Yeah.
me?
Yeah.
What
And
kind
so
of
what's interesting about that is the current annual gift exclusion, which some people have heard about, used to be 10,000 for years and years. And that's sometimes people even still say that number, but it's indexed for inflation periodically over the years. And as of the first of the month, it's currently 18,000. And
A lot
that's
of money.
per person per year. So I can walk out down the street and give $18,000 to every person I meet, and that is legitimate. And my spouse can do the same thing. So sometimes you see spousal couples doubling those annual gifts, and there is no tax ramification to that. Beyond that, let's say I want to give $118,000 to someone. The 100,000 that was in excess of the 18,000 I could give annually reduces my lifetime amount. So the current lifetime amount in Massachusetts is 2 million. So I can give that at death, and most people do. But if I've given 100,000 to my kids above the annual exclusion during my lifetime, now I can only give them 1.9 million at my death. And so that's how the math is supposed to work. I'm not sure there's a terribly good accounting of that, but
I was
nonetheless.
going to say, do they have people like, this
Yeah,
would be the, gifting police, the gifting police. You gifted too much.
right,
Yeah.
right.
Let me know what street you're on. You're giving out 18,000 because I'll be there.
Yeah,
But 18,000, that's a lot of money. I mean, that would help someone get through college,
yeah,
buy a new car, be a down payment on a new home, and it's coming from a grandparent or parent, and it helps offset the estate taxes at the end of the day.
yeah,
I think, it's great,
yeah,
yeah.
absolutely.
I think this was very informative. Thank you
Good.
so much for your time. If
My pleasure.
anyone has any questions, how can they reach you, Nancy? What's the best way?
Yep. So it's either to call the office, which is 978-772-2442, or check out our website. Some answers are on there. That's Addie Catalini Chew, ATTY Catalini Chew, CATALINICHEW. That's a lot of words, I know. If you get close to it, it'll probably come up with me. So there's some information on our website, and they can also email us. My email is Addiechew, ATTYCHEW @addiechew.com. So they can always send an email and I can forward it to whomever to get back to them.
Well, thank you so much for your time, Nancy. This was wonderful. I think I had a lot of great questions and information. So for all your real estate needs, keep the Real Estate Exchange in mind. And thank you again for joining us. Have a wonderful day. Bye, Nancy. Thank you.
Excellent. Thank you. Take care.
Talk to you later. Bye-bye.